Good afternoon, everybody. Thank you very, very much for joining us today and giving up your afternoon. My name is Kieran Duna. I am the branch chair of the Scotland branch. Firstly, I would just like to extend incredible gratitude to Lauren and Amy for joining us today from Brodie Solicitors. Lauren and Amy were with us last December for a face-to-face in the Eurocentral area, and it was incredibly popular and successful. So I just want to say thank you very much for them to come back to talk to us again. Um, Before we kick off, just one or two matters of business. Um, I just want to highlight that RRSM are attending Health and Safety Matters Live tomorrow in the event in Glasgow. You may have seen information about that. So if anyone is going along to that event, be sure to look out for Darren and myself. We'll be knocking around and we'll be at the RRSM stand. So feel free to come over and say hello if you happen to be there. And also, we have another talk for you next Monday, which is quite in quick succession, I know, but an opportunity came up and we just wanted to grasp it. So next Monday at 11 a.m., we have Patrick Ball from Musgrave and Ball doing a talk for us on hidden addiction in the workplace, which promises to be really, really good. That session won't be recorded and won't be available afterwards as a recording because it's quite a sensitive topic and we want people to be able to attend in confidence and that. So just be aware if you are interested in that talk, please attend in person. I think that's it from me. So I'm going to pass you over straight over to Amy, who will introduce herself and Lauren and kick straight off. So thank you, everybody, and please enjoy. We will invite questions at the end, so please pop them in the chat and we will deal with all the questions at the end. Thank you. Over
Thank
to you,
you.
Amy.
Thank you, Kieran. Good afternoon, everyone. Thank you to Kieran and for the Scotland branch for having me along to speak with you today. I'm delighted to be here. Just by way of introduction to me, my name is Amy Anderson. I'm a senior associate in the health and safety team at Brodie's, which is a full service law firm. So I specialise in health and safety law. So I advise clients being investigated by regulators, primarily the HSE, the Health and Safety Executive. I assist them with any investigation that there may be, and thereafter represent them in any court proceedings which may follow. So that tends to be a prosecution for a health and safety offence or a fatal accident inquiry where there has been a death. I also provide compliance advice to a range of clients on various health and safety matters. And due to the nature of the work, my clients span a range of sectors. So from construction, manufacturing, agriculture to commercial property, hospitality, social care, social housing, the full range. And I see that there are people from a range of sectors attending the presentation today, which is really nice to see. So moving on to today's webinar, as you'll know, it is the topic is personal liability of directors and senior managers for health and safety offences. People often consider prosecution for health and safety failings to be a corporate risk alone, so one which affects the company only. But that's not the case. Directors and senior managers can also be prosecuted, and that is them being prosecuted personally. And where that happens, where a director or a senior manager is prosecuted and convicted for a health and safety offence, the penalties that can be imposed by the court are significant. And I'll come on to look at them in a moment. But it is more common now than it ever has been for directors and senior managers to be prosecuted personally for health and safety offences. Which is why when I was speaking with Kieran about what people might be interested in hearing me speak about today, we thought that might be a good topic because it does touch a range of sectors and will be relevant to well, all businesses which are required to comply with health and safety law. So, just briefly today, I want to look at firstly who can be held liable for a health and safety offence. Um, then I'll look at the penalties that can be imposed upon conviction. Then I'll take a look at some previous prosecutions where directors have been prosecuted and what we can learn from those prosecutions. And then finally, crucially for those of you in attendance today who hold a management role within a company, I'll take a look at what directors and senior managers can do to help protect themselves against the risk of prosecution. Now, I should say that I practice in Scotland, so I will be primarily speaking about matters from a Scottish perspective. Um, in practice, some of the elements of practicalities of the prosecution process do vary north and south of the border, but health and safety law is the same. It is UK wide, so it is the same in Scotland and England and Wales. So the what I will be talking about in terms of the duties on directors and the principles that govern directors' liability in terms of health and safety law are the same north and south of the border. So what I am discussing today, whilst I will be speaking primarily from a Scottish perspective, it should be relevant to any of you who operate out with Scotland. So, just moving on to the next slide there. Who can be held personally liable for a health and safety offence? As you will know, under the Health and Safety at Work Act 1974, all employers have two overarching health and safety duties. The first duty is the duty to employees, and that is the duty to ensure, so far as is reasonably practicable, employees' health, safety, and welfare. The second duty is the duty to persons not in their employment who may be affected by the undertaking, so by the business. And that duty is to minimise risk to those individuals so far as is reasonably practicable. So that duty will extend to various third parties. It will depend on the type of sector and the work activity that is involved. But for an example, as an example, it will extend to contractors doing work on a construction site. It will extend to members of the public. So, for example, people walking by a construction site and affected by work that's going on. Or it could extend to, for example, residents in the vicinity of work activities who may be affected by, for example, a gas explosion or a fire. So this Section 3 duty, the duty to those not in employment who may be affected by the business, really is wide ranging, and it is a duty that businesses need to be aware of. Now, aside from these two overarching duties, you'll be aware that there are a whole host of regulations that are specific to a particular sector or a particular work activity. So there are regulations relating to work at height, control of hazardous substances, the provision and use of work equipment, control of asbestos, a whole range of regulations that may or may not be relevant to you and your organisation, depending on the work that is being carried out. But health and safety law generally comes down to these two overarching duties that I have just mentioned there. The duty towards employees and the duty to non-employees who may be affected by the business. So what does that mean? Well, some of the steps that businesses have to take, as I'm sure you'll be aware of, is they have to appoint one or more competent persons who are responsible for health and safety compliance. They have to assess risks to anyone who may be affected by their business activities. They have to plan and organise, control, monitor and review preventative and protective measures. And they had to audit the adequacy of procedures. So what does that mean for directors? These are all the duties incumbent upon an employer, so upon the company. What does that mean for individuals who are directors within those companies? Well, directors need to understand the company's health and safety duties and ensure that the company is fulfilling those duties. And while directors can delegate their duties to competent third parties, they themselves, so the directors rather than the third parties, remain responsible for ensuring the duties are met. And so, what that means is there has to be ongoing engagement at director or senior management level with those responsible for health and safety compliance within the business. Now, very often we see, I have clients who come to me, and I'm told that health and safety is essentially an add-on to another function within the business. So often I see an office manager or an HR personnel who also has responsibility for health and safety. But that person isn't trained, they're not competent, they don't really know what they need to do or what the business needs to do to comply with the law. Um, that's not enough. So health and safety needs to be prioritised within a business, and directors and senior managers need to take the lead on that, and they need to be able to demonstrate that they're taking the lead on that, and that they are treating health and safety as a priority within the business. And we'll come on to look at how they do that, or helpful tips to help those in those positions to do that towards the end of the session. But if we just go on to the next slide, first of all, why is all of this important? Why do we need to look at what directors and senior managers can do to make sure the business is complying with their health and safety duties? Well, aside obviously from the obvious reasons that it ensures people's safety, breach of health and safety duties is a criminal offence. And now criminal liability, as you know, is very different to civil liability. So often we hear about an incident happening and a personal injury claim being intimated to a business following someone sustaining injuries in an incident, for example, at work. Now, that's not what I'm talking about today. Today, what I'm talking about is criminal liability. So I'm talking about businesses and people being prosecuted for a criminal offence. Now, we know we often hear in the news companies being held criminally liable for health and safety offences. And that is where a business, so the corporate entity is prosecuted. But it does often come as a surprise to people that under health and safety legislation, as I said, directors and managers can also be personally prosecuted. And the power to do that comes from Section 37 of the Health and Safety at Work Act. And it enables the prosecution of a director, manager, or secretary of a company or of an organisation for a health and safety offence where the company has committed a health and safety offence, and that offence has been committed with the consent, connivance, or has been attributable to the neglect of a director or senior manager within the business. So, just to break that down a bit, because it is a bit of a mouthful, it is a prerequisite in order for a director or senior manager to be prosecuted for a health and safety offence. It is a prerequisite that the company is convicted of a health and safety offence. So only where that company is convicted can an individual also be prosecuted and convicted. Now, if we look at the offence in a bit more detail, an offence can be committed by an individual where the company has committed a health and safety offence. And as I said, that's been done with the consent, connivance, or neglect of a senior manager or a director. So what does that mean, consent, connivance, or neglect? Consent, first of all, what that means is the person was aware of what was going on. and agreed to it. So that could be a health and safety, the person was aware of a health and safety failing or insufficient practice within the business and they agreed to let that happen. Connivance is that the person was aware of what was going on. They didn't necessarily agree to it, but they were aware that it was going on. And then neglect um, is where that person ought to have known what was going on. And so the failure was attributable to some breach of duty on their part. Now that all sounds a bit legalistic, so it can often help to look at an example to understand exactly what all of this means. So if we picture a distribution warehouse, for example, we have a forklift truck which is having issues with the brakes, and that's been highlighted in the daily defect sheet. A repair contractor is booked for the same day, is booked the same day and is expected on site the following week. However, a large order has been placed and needs to be packed by tonight's night shift. The warehouse manager informs the operations director of this, and it is proposed that by the warehouse manager that the forklift truck remains in use so that they can get this order serviced. The operations director takes this information from the warehouse manager and agrees to it. So that's an example of a director giving consent to a health and safety offence. Connivance, if we think about the same scenario, but the operations director, he or she knows that the forklift truck is faulty, they see it's still in use, but rather than addressing it, he or she turns a blind eye to it and says nothing. So they don't question the use of it, despite it being in a potentially dangerous condition. So that's as an example of connivance. Now, the final one is neglect. Again, we have a similar scenario. The warehouse manager emails the operations director to inform him of the need to use the forklift truck. The operations director goes back to him and says, well, it's his job to get the order filled. Don't bring problems to his door. And that is an example of neglect. So there are subtle differences in each, but all of those scenarios which I've just spoken about could potentially lead to the operations director being prosecuted for a health and safety offence where the company is prosecuted as well because they have consented, connived, or have been neglectful of their duty. So generally, prosecutions will be targeted at those individuals who could have taken steps to prevent the offence. So the Crown, when deciding whether to prosecute an individual, will look at directors and senior managers and consider whether they have sufficient responsibility within the company to have taken steps to prevent the offence. And if they did have sufficient responsibility and they did have sufficient power to prevent the offence, did they do so? And usually the answer to that question will be no, where the health and safety, well, it will always be no where the company is prosecuted for a health and safety offence. So the key questions the Crown will be looking at is what did the director or senior manager know? What ought they to have known? What did they do with the information that they were given? And what could they have done with the information that they were given? So these are all the questions that will be looked at by the Crown when they are considering whether or not there has been the consent, connivance, or neglect on the part of a director or senior manager. So if we just move on to the next slide, we can have a look a bit at what happens when a director or senior manager is prosecuted for a health and safety offence and is ultimately convicted. And in short, the penalties can be really, really serious. So the first power that the court has is they can impose an unlimited fine on the person who has been convicted of the health and safety offence. Now, certainly we hear about companies being convicted and fined for health and safety offences. Fines, I'm sure many of you will be aware, they are regularly in the hundreds of thousands, if not millions of pounds. And fines to an extent are based on the turnover of the company that's being prosecuted. Now, for individuals, it's slightly different. But the court will have to take will take account of the financial circumstances of the offender, which can lead to a whole range of fines. Now, a key point to note when talking about fines being imposed for a criminal offence, companies will often have insurance policies to cover where the scenario where an award of damages is made to a personal injury claimant. So where damages have to be paid, it will be the insurance company who pays that sum of money to the injured party. That is not the case with fines for criminal convictions, whether that's the company being fined or an individual. So where a fine is imposed, that has to come from either the company or the individual's own pocket. So it can have a significant impact on the company or the individual. Um, what people tend to be a bit more concerned about, though, rather than the fine being the main concern when an individual is being prosecuted, the court can also imprison an individual for up to 2 years where they are convicted of a health and safety offence. Now, within, as I said, that's up to a maximum of two years, and there are guidelines which govern how the extent of the prison sentence and the matters that the court will look at when determining the sentence to impose. But for example, where there's been a high likelihood of harm arising, and an individual has been found to have acted deliberately or with complete disregard to the law, the starting point for the sentencing range when the court is considering the sentence to impose, the starting point will be 18 months with a category range of 1 to 2 years. At the other end of the spectrum, where there has been negligent culpability, the court will use a starting point of 26 weeks, and the category range generally will be a maximum of 18 months. Will be maximum a year. So that can be quite alarming to people that they could end up in prison simply for carrying out their job, their day-to-day job. Now, what can also be imposed is a community payback order. And that's a type of community sentence. Now, that's a direct alternative to custody. So, what that means is that the court deems the offence sufficiently serious to impose a custodial sentence, but due to the personal circumstances of the offender, then prison is not the appropriate option. So, for example, the types of community orders that we see for health and safety offences is generally unpaid work. So an offender a court can impose up to 300 hours of unpaid work on an offender in Scotland. Now, suspended sentences is something we hear quite a lot about in England and Wales, and that is where a custodial sentence is imposed, but it's suspended for a period of time. And if an individual doesn't commit any further offences during that period of time, they will not serve the custodial sentence. Now, that is not an option in Scotland. If you receive a custodial sentence in Scotland, you will be going to prison. So that is something else that we need to all be aware of when understanding the penalties that can be imposed upon conviction. Now, aside from the fines and the prison sentence that can be imposed by a court, following conviction, a court can also make a disqualification order against the person who has been convicted of the offence. So they can disqualify that person from acting as a company director for up to 15 years. So again, a really, really serious implication of being convicted for a health and safety offence. I think all in all, if you look at the repercussions and the implications, it really drives home the importance of ensuring that a business is complying with their duties under health and safety law, and that directors and managers are complying with their duties and are ensuring that the company itself is complying with theirs. So just moving on to the next slide, I wanted to take a quick look at um, some previous prosecutions that we have seen where a director has been prosecuted for a health and safety offence, and hopefully by doing that, it will kind of bring it all to life, and you can see the sorts of situations where directors have been prosecuted and convicted. So the first case I wanted to look at was a case of Craig Services Limited, and that was a conviction in 2017. And this was a Scottish case. It was a Scottish company where the director was jailed following conviction, following the company being convicted. Sorry, the director was jailed for a health and safety offence following a conviction of the company in relation to the collapse of a cherry picker that led to the death of one person and another person suffering serious injuries. Now, just looking at the case in a bit more detail, Mr. Craig was the director in this case. He was the director of this small business that hired out the cherry picker. Prior to the fatal incident, the main boom of the cherry picker had buckled while in use for reasons that were unexplained. There were discussions between the company and the manufacturer over liability in relation to the failure of this. And the company decided to repair rather than replace the boom. Mr. Craig assured a welder who was undertaking the repair that the cherry picker would in future be used for short reach work only, and the repair was carried out on that understanding. Now, Mr. Craig also provided some confusing information to the person carrying out the repair, and as a result of that, the repair wasn't anywhere near strong enough. So, following that repair, the machine was hired out on a number of occasions without having been certified as safe. And one examiner had refused a certificate on the ground that the repair had not been approved by the manufacturer. The fatal incident occurred a number of months later, and it happened when the machine had been extended to a height of 30 metres, which was beyond the short reach that Mr. Craig had informed the person carrying out the repair that the cherry picker would be used for. So, following that incident, the company was convicted of charges of failing to maintain the cherry picker in efficient working order and in good repair, and for failing to ensure that it was thoroughly inspected at least every 6 months in line with the statutory duties. So, the company was fined £61,000. And Mr. Craig was also convicted personally of a health and safety offence. And when passing sentence, the sheriff stated that Mr. Craig was at the heart of every decision made in relation to the cherry picker and therefore shares the guilt of the company. The sheriff found that he had done nothing constructive to find a solution to the issue with the cherry picker, and he had done everything he could to push the cherry picker back into service. That included lying and misleading others, attempting to foist the company's responsibility for safety onto others, and in fact hiring out the cherry picker. And the sheriff continued to say, in doing all that, Mr. Craig gambled with the lives of those using the cherry picker with fatal consequences. And crucially, he said Mr. Craig's breach of duty is so serious and had such tragic consequences that I can see no alternative other than a custodial sentence. The maximum custodial sentence I can impose is one of 2 years imprisonment. And so that is the sentence that was imposed on Mr. Craig. Now, here clearly the circumstances of the offence were particularly serious, but it shows that where a serious offence has been committed, the courts will come down hard on directors. So in this instance, the court imposed the maximum 2 year sentence that they could impose. So they will do that, and they do that where they consider it appropriate. So that is a bit of a warning to anyone who is a company director or is involved in the management of health and safety within companies. Now, the second case I want to look at is the case of Stonehurst Estates Limited, and that was a company and a director who were convicted just last year, 2024. Stonehurst Estates were involved in converting commercial buildings to residential apartments. In the course of the work, two labourers cut metal tie rods which provided structural support for an arch that formed part of a coal store within the commercial buildings. Neither of the labourers appreciated the structural significance and of what they were doing, and ultimately the structure collapsed onto them, and one of the labourers very sadly was crushed to death. Stonehurst Estates, it was found, had worked on the sensitive structure without a proper plan or sequence in place, despite safety measures being known and being readily available to the company. It was also found that none of the men working on the building had any expertise in demolition work, and there was no risk assessment or safe system of work in place for the task that was being undertaken. Now, crucially for this case, the sole director of Stonehurst had assumed the role of project manager and had overall responsibility for the job. Ultimately, the company pled guilty to corporate manslaughter and a health and safety offence and was fined £450,000. And the director himself was prosecuted and was sentenced to 23 weeks imprisonment. And that was suspended for 18 months because this was a case that occurred in England, and so a suspended sentence was available. And on that case, the site foreman was also convicted of a health and safety offence for failing to take reasonable care for those working on the site, and he was sentenced to 130 hours of unpaid work. So again, this really drives home the importance of planning jobs to ensure they're done safely, so making sure risk assessments and safe systems of work are in place, and ensuring the competence of those carrying out the job. In terms of the role of directors, here, as we saw, the director was directly responsible for the job. He had the responsibility and the authority to ensure the work was done safely and essentially to prevent a health and safety offence being committed, but didn't take steps to do so, despite him having that power and authority. And so again, in these circumstances, we see an individual being prosecuted and being hit with some, a really, really serious sentence following conviction. Now, just looking at a final case, it's a case of FDS Waste Services Limited, and this was a conviction from 2022. In this case, there was an employee who was hit by a reversing shovel loader while sorting recycling materials. Unfortunately, he suffered catastrophic injuries and died. The company was subject to a joint investigation by the HSE and the police, and what that uncovered was significant failings by the company to put in place sufficient working practices to safeguard employees. And it also found that the company had failed to provide adequate training and supervision to prevent such accidents arising. And the management of the site was described as lax and complacent, and that it was that which had ultimately led to unsafe working practices at the company's base. The company was convicted of a health and safety offence relating to that incident, and at the same time, the company was also convicted of a health and safety offence in relation to an entrapment incident that had happened 2 years after the first incident, um, in which a different employee had suffered serious injuries. Ultimately, the company in that case was fined £640,000, and the director was given a 6-month prison sentence. And again, that was suspended for 12 months because this was a case in England. But in Scotland, you wouldn't have the option to, the court wouldn't have the option to suspend the sentence. So again, this really highlights the importance of directors ensuring that staff are sufficiently trained and supervised in the work that they're doing and that sites are properly managed. And again, where it's found that directors have that power to prevent the offence occurring, so that responsibility and that authority to take steps to prevent health and safety failures within the business, they need to be taking those steps. Otherwise, they are open to prosecution and really serious penalties if they are convicted. So, just moving on to the next slide. I want to just finally take a look at what directors and senior managers can do to protect themselves against the risk of prosecution. As I said earlier, directors need to understand the company's health and safety responsibilities and their own responsibilities as well. If they themselves aren't qualified or competent, they should be engaging competent people to manage health and safety within the business. But as I've said, they can't simply delegate their duties and thereby escape liability. Directors will always remain responsible for ensuring the company complies with its health and safety duties. Now, how they do that will depend on the size of the business and the role of the director. So, for example, for a small company that has only one director, that director will inevitably be regarded as exercising control over and having responsibility for almost all activities. So, as we've seen in the examples we've looked at, that person will have direct control over work being carried out. And so they have to make sure that they are doing all that is reasonably practicable to minimise risks on the job. So that will include effectively planning the job, so risk assessing the job and implementing effective control measures. They will have to ensure suitable work equipment is being used, so ensure it's suitable for the job and that it's been sufficiently maintained. And they'll have to audit jobs to ensure procedures that have been set by the business are being followed. Now, where there is a slightly larger business and there's perhaps more than one director, it might not be so clear cut who has control over certain operational matters. Now, as I touched on a bit earlier, where the Crown are considering prosecuting a director, the fundamental question will be the measure of control and responsibility that the director had over the tasks or the systems of work that were in operation. Within the company, there because of that, within the company, there should be a clear delineation of duties among directors. So companies should make sure that it's clearly understood and agreed in writing which director is responsible for what. So, what is each director's function? What is their role? And what authority do they have within the business? Now, for larger businesses, they may have a board of directors who might not be involved directly in the day-to-day operational side of the business. And so for them, engagement with health and safety within the business might look a bit different. Um, because usually the practicalities of job planning and systems implementation will be delegated to others. And so the directors have to have ongoing engagement with those individuals to ensure health and safety is being adequately managed. And the Health and Safety Executive has published really helpful guidance on leading health and safety at work. And it's guidance for directors and board members. And the steps, it sets out steps that those individuals can take to ensure that they are leading from the top down and ensuring good health and safety management within the business. Um, and it contains a 4-point plan for directors and board members. And the plan is based on the Plan, Do, Check, Act model, which you'll see there on the slide. So directors have to plan the direction for health and safety management within the business, establish health and safety objectives, identify hazards and risks, and determine necessary control measures. Then the do section is they have to implement the health and safety plans and procedures, and ensure proper resources and competent advice are available. Then they move on to check. So directors have to monitor and measure the performance of health and safety measures, track incidents and track incident reports and conduct audits, and evaluate whether the implemented controls are effective and goals are being met. And then the final stage is act. So directors have to respond to observations that have been made during the check phase, review performance, and make any necessary changes to improve health and safety management. So, in essence, directors need to ensure that they are being given that those responsible for health and safety within the business are reporting to them on how health and safety is being managed. But it's not enough that directors are given these reports and receive these reports. Directors have to take an active role. They have to be looking at these reports and considering the trends, looking at incidents and near misses and considering what can be done, if anything, to continually improve health and safety within the business. Now, just very, very briefly, because I am mindful that we want to leave time for some questions at the end. Just one final point to note, and it's really a practical point about what directors and senior managers can do to protect themselves if they are being investigated. Many of you will be aware that where the HSE are investigating health and safety management within a company, they have wide powers to conduct that investigation. And one of those powers is to take statements from anyone who may be able to provide relevant information. There are two types of statements that the HSE can take from individuals. The first one is a voluntary statement. And that is what it says on the tin. It is a voluntary statement, and therefore anything that individual says can be used in evidence against them should that person be prosecuted further down the line. The second type of statement is a compelled statement, and that is where the HSE use their powers under the Health and Safety at Work Act to compel a person to provide information. And because of the principle against self-incrimination, anything that the witness and the person says within that statement nothing within that statement can be used as evidence against that individual if they are ultimately prosecuted for a health and safety offence. So we would always recommend that anyone who is at risk of personal prosecution, so that will be company directors, senior managers, health and safety managers, operation managers, anyone who is at risk of being prosecuted further down the line, we would always recommend that they give a compelled statement to the HSE so that nothing that they say within that statement can be used in evidence against them if they are ultimately prosecuted. Now, you might not think at the early stages of an investigation that you will ultimately be prosecuted, um, but it is very often simply too early to tell whether or not there is a risk of prosecution in the immediate aftermath of an incident where the HSE are there taking statements. So we would always say, even if you think that there is no risk of prosecution of yourself or any of your fellow directors or senior managers, just to be on the safe side, we would always recommend that you give a compelled statement. And similarly, um, if there is any hint that you, as a director or a senior manager or any of your colleagues, are being investigated personally for a health and safety offence, you should make sure that you have separate legal representation. Very often, a company will have legal representation where there is where there's an incident, where there has been an incident, and that is being investigated by the health and safety executive. But bear in mind, if there is any hint of an individual being looked at personally for prosecution, then that person will have to get separate legal representation because the company solicitor will not be able to act for both the company and that individual. So take advice early, and make sure that you are doing all you can to protect yourself from prosecution or to put yourself in the best possible position should a prosecution follow. So that is it from me at the moment. There are a few questions in the chat box which I can have a look at just now. In the meantime, while I'm doing that, you'll see there's a QR code on the screen. If you that is a QR code that will allow you to sign up to Brodie's Health and Safety mailing list. So if you're interested in hearing any more from the Health and Safety team, then please do sign up to the mailing list and you will be put on the list and you will be sent out any blogs that we publish and details of any webinars that we do. So I will just have a quick look at the chat box just now. Okay.
Hi, Amy. That was absolutely superb. Thank you very, very much. There was a question from John in the chat, and I think a second question has been kindly passed over into the chat from Joanne as well. So
Okay.
I can help you find them if you
Yeah.
like.
Thank you. So I have, there's a question here from Joanne. Are there more cases involving smaller businesses rather than large blue chips, as identifying those directors with responsibility is easier due to less complex organizational arrangements to those seen in larger organizations? Yes, absolutely. We tend to see prosecutions of directors of smaller companies exactly for the reasons that you have outlined there. It is easier to establish or for the Crown to establish that there has been consent or connivance or neglect on the part of the director. Um, as I've said, they will be looking to see, what authority and power did the director have to prevent this offence occurring. And the larger the organisation, the smaller that authority and that power. So yes, it tends to be that we see directors of smaller businesses being prosecuted more often. So let me have a look. And a message from Anthony. Are you are speaking more specifically about senior managers? I would assume that managers at a lower level also get caught in this. Yes, again, it's really all about the control that that person has, the control over the working practices or the job in question, and the power that an individual has to change working practices. So yes, you can. I have been using the term senior manager because it tends to be those in senior management positions who have the power to change working practices and to prevent health and safety offences being committed by the company. Um, but just be aware that there is the potential to prosecute an individual at a lower management level, or indeed any person at work. They can be prosecuted under Section 7 of the Health and Safety at Work Act for failing to take reasonable care to those who they are working with. So there is the potential for prosecution really at all levels within the business. You have corporate level, director and senior management level, but then also at a lower management level and operatives on the ground.
Thank you, Amy. There is a question further up in the chat as well from John Connolly. I can call that out to you if you like, or if you scroll up, you might prefer to
So,
read it.
okay, are there any examples of health and safety managers or advisors being subjected to successful prosecution? Oh, hang on. And leading on from that, what practical examples can we do as professionals to ensure we avoid prosecutions? Yeah, so there was a case a few years back whereby it wasn't quite on this point, but it was a company was convicted of a health and safety offence, and if my memory serves me right, they then tried to recover the fine that was imposed from their health and safety advisors on the basis that they had been given defective health and safety advice. The court ruled that that was not possible. So it was not possible for a company to sue their health and safety advisors for providing deficient advice and to recover the fine. And that was for reasons of public policy. Essentially, if a crime has been committed, then that fine, the punishment or imposed for that offence should not be able to be recovered from a third party unless in certain circumstances. I suppose that's not quite what you're asking, though. Are there examples of health and safety advisors being subject to successful prosecutions? Um, I'm assuming when you say this, you're meaning external advisors, so third party advisors. Um, I think it would be quite difficult to establish that a health and safety advisor has committed a health and safety offence. I mean, the duty is on the business, on the company. They have the duty to ensure the health and safety of their employees and non-employees. So I think if you are talking about third party advisors, whether they could be prosecuted for a health and safety offence that has been committed by a company, by one of their clients, then no, I don't think that would be possible. Um, right. Are there any other questions? Kieran, do you see any other questions there?
I can't see any just now. No. I just had a brief one for myself before we wrap up.
Yes.
Well, it's more of a statement, maybe. This trend doesn't seem to be going away. There's a trickle of these types of cases and prosecutions going on all the time. So you don't see this trend changing suddenly all the time. It's probably just going to be more commonplace. Would that be the position, do you
I
think?
I would say so. I would say so. There does seem to be a real drive to prosecute individuals as well as companies. A few years ago, we would have seen the Crown, maybe saying to us as defence lawyers, "Oh, we are intending to prosecute the company and the director, for example, the operations director." Um, but they would ultimately accept a plea just from the company alone. But that doesn't seem to be the case. There seem to be more and more examples of both the company and the directors being prosecuted. And I don't see that trend going away anytime soon.
That's fantastic. We're just coming up to 2 o'clock now, so I would just like to thank you very, very much to Amy and Lauren for giving up their time today. You'll see the opportunity to sign up to their mailing list there on the screen. So if you require any legal advice at all, please feel free to reach out directly to Amy and Lauren. They're both on LinkedIn. If you want to get the quick route to quick route to getting in contact with them, and we thank you again for your time, and we hope to see you talking to us again sometime in the future. Thank you so much.
Thanks, everyone.